Here are three truths about our justice system so you don't look like a. Number one, there are multiple instances where you may end up in court suing someone, dealing with immigration status, having your rights violated, someone breaking a contract, or, Lord forbid, you're accused of murder.
A couple people getting killed by one guy with a knife is not that big of a deal.
Only the last one guarantees you an attorney under the Sixth Amendment. Unless your case involves a chance of going to jail, you'll either have to represent yourself or find representation and pay out of pocket. Two, if you decide to find representation, you may think that it's easy, but that's also a myth. There's this huge justice gap for the average American trying to get legal help. All states offer some kind of legal aid, but you only qualify if your income is near the poverty line. For example, in North Carolina, an individual can only make about $20,000 a year. Anything over that, no legal aid. And most likely hiring a lawyer means that you're going to be paying per hour. You may have heard about lawyers working on contingency, meaning they don't get paid unless they win, but that only happens in personal injury cases and only when there's a very clear, easy payout. Attorneys charge anywhere from $100 to $600 per hour, but let's go someplace in the middle, around $300 per hour. Now, the average civil case can take up about 50 hours. Now, that's $15,000 in legal fees. For the average American that's making around $53,000 per year, that's about 25% of their income before expenses for something that doesn't even guarantee a win, especially if you don't have a good attorney.
There you go. No wonder he gets 300 an hour.
Which leads me to number three. If you choose to represent yourself, courts are supposed to be accommodating to pro se litigants, which is the legal term for self-representation. They might recommend resources for you to learn about your case, but here's what they don't tell you. Courts are inherently biased against pro se parties. Judges and court staff often see them as a burden. Multiple university studies show that self-represented litigants are frequently mistreated in court, I can attest to, which violates the official judicial code of conduct. Part of the problem is, though, that people don't know the rules or law before going into court. Courts don't actually tell you what you need to know. They might hand you a guidebook, but it often leaves out critical, relevant case law, local rules, or obscure acts or decrees that you need to understand. For example, in my own case, I've had to learn the North Carolina and federal rules of civil procedures and the rules of evidence, rules of professional conduct for attorneys and judicial canons for judges, Wake County small claims statute, state district court rules, and Wake County district court rules, state rules of appellate procedure, Eastern and Middle District local federal rules, administrative law, Fair Housing Act and HUD regulations and the U.S. Code around that, constitutional law and civil rights, along with various federal acts and doctrine that aren't even a law. However, if you are representing yourself in federal court, you only win about 3 to 4% of the time. That's compared roughly to 50% with both sides having attorneys. The odds are definitely not in your favor, but that doesn't mean you shouldn't try.